Welcome to the Business for Breakfast seminar series presented by Huddleston Bolin. Business for Breakfast seminars provide very practical information for business people on topics ranging from sales and marketing to customer service, employee relations, technology, and accounting. For information about upcoming seminars, go to www.huddlestonbolin.com/events. Speaker today is Kevin Nelson, who's a partner here in the firm. He's the manager of our Charleston office.
And particularly, we're going to talk some about it's not really symbiosis, it's kind of a lack of symbiosis between, or when you have issues involving the ADA and FEMLA, because there are different potentially there are conflicts between the two in terms of what an employer is obligated to do, and while you may feel that you have certain options available to you with an employee who has reached the end of their FEMLA leave, say, you still may not be able to take action against them because you still may be obligated to reasonably accommodate them if they are a person with a disability as defined by the ADA. So what does the ADA require? In simplest terms, it requires an employer to provide reasonable accommodation to qualified individuals with disabilities who are employees or applicants, except when the accommodation would cause undue hardship. Once a complaint was filed, then the lawyers would go about doing battle to determine whether this person was a qualified individual with a disability. A lot of the ADA cases focused on whether the person was disabled as defined by the Act. The current administration kind of said enough is enough. What you all should be doing as employers is figuring out how you can accommodate these people, not trying to figure out whether or not they're disabled. And so a bunch of new regulations were issued which essentially take the disability question, in my mind, out of play in terms of litigation. And I think now when you represent employers who have been sued for an alleged violation of the ADA, in almost all circumstances, I assume that the plaintiff is going to be, under the regulations, someone who is a qualified individual with a disability. And then we go about deciding whether or not this person could be accommodated in their position or a different position, and then whether or not they were qualified for that position. Reasonable accommodations under the ADA must be provided to all qualified individuals, whether they're full or part-time, or whether they're probationary or regular employee, I guess you could say. So what kind of things might reasonable accommodation entail? It could be as simple as making existing facilities more accessible. It can require you to restructure your job in terms of the hours worked, days worked. It could include modifying a schedule from full to part-time, acquiring or modifying equipment, changing tests or other policies. If you do employment testing, I think then you also have to be concerned not only about well, it depends if we're talking about physical exertion type tests or if you're talking about written tests, but I think potentially if you're talking about written tests, IQ tests or things like that, then you also have to be concerned that you may be accused of running foul of Title VII by discriminating on the basis of some other protected class other than disability too. There, just to talk about a few modifications or adjustments that would not be considered a form of reasonable accommodation. A lot of what we talk about now in litigation in ADA cases is whether the individual can perform the essential function of a job. An employer doesn't have to eliminate what it says is an essential, well, what a court finds ultimately is an essential function of a position in order to accommodate someone. And that is because the definition of a qualified individual under the ADA is that if an individual cannot perform a an essential function of the job, then they're not qualified within the meaning of the ADA. And an employer is also not required to lower production standards or any other qualitative standard with regard to a position, as long as those standards are uniformly applied to employees with and without disabilities. In most circumstances, I think the employer needs to, first of all, educate your supervisors and anybody who may be dealing directly with employees in terms of what to listen for and how to react to what they're being told by an employee, because in most circumstances, if an employee is coming to you and telling you that they have a medical condition and they need some sort of change in the term or condition of employment, then what they are telling you under the ADA is that they believe themselves to be a qualified individual to whom you need to provide a reasonable accommodation. If you believe that you've been told that somebody is requesting a reasonable accommodation for an employee, you probably ought to document via letter or memorandum in the file and provide them a copy of it that this is what you understand their condition to be, this is what you understand their request to be, and this is what you believe you can or will do to reasonably accommodate the request. Or you can ask them to fill out a form. But even if the form is never filled out or you don't memorialize anything, doesn't mean that you don't have to provide that reasonable accommodation if you think that that's what the employee has requested. A request for reasonable accommodation, what does an employer have to do? They should engage in conversation or communication with the employee to determine what can be done to reasonably accommodate this individual's condition or request. And I think that's one of the things that prompted the changes in the regulations in the ADA. Again, as the EEOC was saying, look, we don't want you fighting with your employee about whether or not the employee is disabled. What we want you to do is we want you to engage in conversations with this person to figure out how you can keep them as a productive employee instead. And so I think this dialogue is something that's particularly important for you to engage in, and I also think it's important for you to document it, even if these are just conversations that you're having, and that's fine, to not write everything down in terms of memorializing it with the employee. I would encourage whoever, whether it's someone in HR or someone in management who's engaging in the dialogue with the employee, do a memo to the file afterwards and say, I talked to Jane today. This is what she said her problem is. This is how she says she thinks she needs to be accommodated. So now my next step is I'm going to go talk to Bill to see if Bill thinks that we can accommodate her in the manner that she requested, or if there's some other means of accommodating that'll be less intrusive, less expensive, will work less hardship on the employer. So can an employer ask for documentation if there's a request for reasonable accommodation? The answer is yes. The employer is entitled to know what the particular basis is of the employee's asserted disability, but you can't ask for documentation that's not, and you don't want to ask for documentation that's unrelated to the condition. If one of the many reasons why is because you don't want to set yourself up for another potential class of lawsuits, whether it be under GINA, whether it's workers' comp discrimination. I mean, let's say you have someone who comes to you who says they have some sort of congenital condition. You request all of their work records, and you realize that they filed a workers' comp claim with regard to a previous employer. I think you're exposing yourself potentially to other types of lawsuits other than just an ADA suit if you're receiving medical information other than that that's specifically related to the condition for which this individual is now seeking a reasonable accommodation. Can you refer someone who believes they are a qualified individual out for disability determination of your own? The answer to that is yes. if you believe that the documentation they've provided is insufficient, then you need to let the employee know that as well. And if you believe the documentation is insufficient, but you don't take actions to get your own information or to verify what the employee is telling you, then I think under the regulations now you have to accept that that individual is someone who is qualified or who is at least disabled, and then maybe you can make the decision of whether they're a qualified individual with a disability, in that you still are able to determine whether they can perform the essential functions of the job.
Presented by Health.
Or when the different, potentially there are conflicts between in terms of an employee. While you has reached leave, say, still may be if the is defined. What does the ADA require? And simply it requires an accommodation to qualified individuals with disabilities who are accommodation would is focused on by the Act. Position or disposition and thought they were qualified.